Hello and welcome. I'm Dawn Smalls, and I am co-chair of the New York City Bar Association's Task Force on Civic Education and a partner in the New York office of Jenner and Block. And I want to welcome everyone that has joined us today in celebration of Law Day for this very special conversation with Damon Hewitt, the president and executive director of the Lawyers Committee for Civil Rights under Law. Damon is an experienced litigator and policy expert who has devoted his career to civil rights lawyering with over 20 years of experience in the nonprofit, philanthropic, and public sectors. Prior to this role, he spent over a decade, which is where we first crossed paths, I believe, but the history is long. He spent over a decade as an attorney at the NAACP Legal Defense and Education Fund, where he was lead counsel on a variety of litigation and policy matters and supervised teams of lawyers and policy experts. The theme of this year's Law Day is Voices of Democracy, with an eye towards this year's elections. So let's turn to that. Let me just again say thank you to Damon for joining us today. Again, let's turn to the elections. And it's elections where many say that democracy is on the ballot. What are you preparing for, and what are you most concerned about?
Oh, thank you, Don. First, thank you for having me. Thank you to the City Bar. And thank you for shining a spotlight on these critical issues regarding voting, elections, and democracy. They seem to be issues that are always with us, but issues that are so sometimes challenging to address and to think about that people end up accepting the status quo, or accepting that some difficult or bad things will happen, and we should not accept that. So thank you for bringing a solutions-oriented focus to it always. And also thank you for being a champion of democracy in your own work, especially in your pro bono work. I really appreciate and respect what you've done in your career. To your question, there was a time where we were worried about general election administration. Will there be enough paper ballots? Will there be paper backups? Will there be hanging chads? Things of that sort. Those are basic issues, important but very basic issues. But really, since 2016 and beyond, and it really peaked in the 2020 election cycle, we are getting lots more reports and lots more concerns about things like voter intimidation, whether it be in person or even sometimes through the airwaves or online on the internet, misinformation, disinformation, which is not new. That's happened, throughout the course of history. Frankly, as long as we've had elections, we have had racial discrimination in voting. We've also had racial discrimination in terms of disinformation, but it seems to really be
supercharged now.
It's supercharged now, exactly. Supercharged. It is powered by modern technology. It is powered, as we've seen, by the internet. It's powered by AI, artificial intelligence. It's powered by the coordination and the orchestration of campaigns for voter disinformation, which I hope we can talk about down the line. So, if you just look at the political climate, not just partisan politics, but just heated debates happening in this country right now, there's something healthy to debate, but sometimes these debates take upon this character of, life or death polarization, very strong entrenchment. And so that can get really scary for folks, and it can lead people to feel unsafe, and it can lead people to do things that are, out of character, and those for whom it is in character, it emboldens them as well. So these are very difficult times when it comes to the crown jewel of democracy, which is the right to vote.
So let's talk about that. Specifically, this election is coming after sustained attacks on voting rights, both at the federal and the state level. And I know that you recently testified before the Senate Judiciary Committee on this issue. Can you tell us what remains of the VRA after, the recent Supreme Court cases, Shelby County and others? And is there anything we can do to buttress the core right to vote that our ancestors fought for, and access to the ballot for marginalized communities?
Right. Well, it feels like when you're on a roller coaster, for those of us who used to ride those, you feel the anticipation, in that case with excitement, in this case with trepidation, of a downward slope. But you also know two things. At some point, the slope will go upwards. And at some point, the ride, scary or thrilling, will end and you'll get to revisit it and relive it. Well, that's not necessarily the case here. I'm not sure that where exactly this ends. When the Supreme Court decided almost 11 years ago, the Shelby County v. Holder case, the case that gutted the heart of the Voting Rights Act, which was the pre-clearance provision, which provided that jurisdictions with a documented history of racial discrimination in voting, that they had to have any changes to voting, whether it be changes to mail-in ballot requirements or eligibility or polling places or polling hours. Those changes had to be pre-cleared or pre-approved by either the U.S. Department of Justice or a three-judge court in the federal court, three-judge panel. And so that Section 5 had a prophylactic effect. It allowed us to stop bad things from happening before they actually happen. When the Supreme Court gutted the formula or struck down the formula that really made that act work, that part of the act work, we were left with Section 2 of the Voting Rights Act. And in fact, one of the opinions in the case said, well, you still have Section 2. Section 2 of the act, of course, prohibits vote denial or vote dilution, especially on the basis of race. And so what
And
we
let me
see
just jump in, because I think it's important context. If you can talk a little bit about where these sections applied, where just regionally and with respect to which communities this really had the most applicability, because I think that really illustrates the point in terms of what the challenges are.
Sure. So there were a set of jurisdictions that were covered by the Voting Rights Act, and this was based upon a formula, which I won't get into the details of, but you saw certain states covered as a whole: Alabama, Alaska, Arizona, Georgia, Louisiana, my home state, Mississippi, South Carolina, Texas, Virginia. And then you saw a number of counties covered in states that weren't covered as a whole: multiple counties in California, multiple counties in Florida, multiple counties in New York, multiple counties, a lot of them in North Carolina, darn near statewide, but not quite, South Dakota as well. So that's the coverage was based upon a formula based upon voter registration, voter turnout and participation. The logic being that if there was no participation, it was likely because of a chilling effect, because of ingenious devices like literacy tests and poll taxes, at least circa mid-1960s, that were designed to deter people from being able to vote. And so those are a sampling of the covered jurisdictions for Section 5. Section 2 can apply anywhere in the country, but Section 2 is not a prophylactic. There's no pre-clearance requirement. It allows us to address discrimination essentially after the fact, after it's already in motion. It doesn't mean after an election, however. If an electoral map, in the case of redistricting, or a new voter restriction is adopted, as we've seen in states like Texas, Georgia, and so many states around the country, since the Shelby decision, but really since the 2020 election, which is a really interesting piece. That's when they really proliferated. We have seen so many of these things pop up, these negative regressive voter suppression laws, as we call them. And so we're able to sue before those laws actually take effect. However, the wheels of justice turn very slowly. Section 2 cases are extremely time-consuming, lengthy, very expensive, very fact-intensive, expert-intensive. And so they're no substitute for the prophylactic power of Section 5. But we do have Section 2 available to us. Unfortunately, in 2021, in an opinion by Justice Alito, in the case Brnovich v. DNC, the court made it more difficult to prove these vote denial cases. And what was so interesting is Justice Alito resuscitated this language from a prior case, the Marion case, the county case about voter ID. And he referred to what they call the usual burdens of voting. I repeat that, the usual burdens of voting. And it kind of makes you think that there's a sense that, well, you should have to jump through some hoops to vote. It shouldn't be really easy. You should have to prove your bona fides. And so that is really not what we want to mainstream in this country. It really is consistent with the notion that some people have that is better for me or my kind or my party or my election if fewer people vote. That is anti-democratic at its core, and I believe is un-American as well.
So let's talk, you mentioned Alito. A 2023 NPR PBS poll indicated that 62% of Americans said that they do not have very much or have no confidence in the Supreme Court. How do we move forward and buttress the rule of law with confidence in the Supreme Court and more broadly our institutions frame?
Well, what a great question. And it's so difficult. There was a commission a couple of years ago, that President Biden commission, and a number of people that you and I both know populated that commission, people of all political stripes. And it was all about Supreme Court reform. Where should the court go from here? And of course, there were no hard and fast recommendations or let alone consensus on the big issues, but the proposed ideas were things such as term limits for the Supreme Court, maybe have them riding circuit so they wouldn't be kind of ensconced for life there, and also perhaps the court expansion. And various groups took various positions across the political and ideological spectrum. But even those kind of provisions, I don't think will restore faith. What we're facing is the rights that we once took for granted, seem to be taken away from us. When the Supreme Court decided the Dobbs decision, the reproductive rights decision, it was the first time that the court actually took away a right that we viewed as fundamental. In the past, the court would either grant rights, or I would like to think of as recognizing rights that already existed in the Constitution, recognizing them for the first time. But this was the taking away of a right. And so you see a through line between cases like Dobbs, cases like Shelby County, cases like the Students with Fair Admissions versus UNC and Harvard, which we argued in the Supreme Court. The Lawyers Committee represented students at Harvard and UNC from trial through Supreme Court. Those are really tough losses. And what we see is essentially not just a backsliding, but kind of a very strong, forceful drive backwards. And it's not necessarily based upon an evolution of jurisprudence. It's really happening because they can do it. Quite simply, they're doing it because they can. And so it's very difficult to have faith, because to lawyers and lay people alike, these decisions seem intellectually dishonest. They seem to ignore lived experience of Black and brown applicants to universities. They seem to ignore the lived experience of Black voters who have to stand in very long lines just to be able to cast a ballot and face the same kinds of distortion and confusion that really is akin to poll taxes and literacy tests and grandfather clauses. It seems to ignore the lived experience of women who now have to live in fear for their own health. And so it's the intellectual dishonesty that really gets me. And I think whether people use that phrase or not, I think that is really what people are feeling in this country. I think, how we restore faith is not just in positive decisions from the court. I think it could come from something that feels out of reach right now, depoliticizing the nomination and confirmation process in the Senate. I think some say it's the court that did these things. Others say it's the Senate that has done it. Right?
How do we do that? How do we depoliticize the Senate confirmation process?
You depoliticize the confirmation process through politics, which sounds counterintuitive, but it's true. More people the more anyone tries to make it harder to vote, the more I want to see people come out to vote and fight against that current. It's about making voices heard. But there's also one other piece. You asked earlier about what's left of the Voting Rights Act and what can we do. Here's something we can do. I don't think that we should rely only on federal legislation as a pathway forward, but there is something that a lot of people in this country overlook or misapprehend. There is no fundamental right to vote written into the Constitution. The Constitution does not, at a baseline, give everyone the right to vote. It gives us the right to not have our voting rights impinged based upon race, creed, or former condition of servitude, as in being enslaved, right? That's a Reconstruction era amendment. the 15th Amendment. But we don't have that baseline right to vote. Just the way the Supreme Court decided in San Antonio v. Rodriguez, I think in 1973, that education is not a fundamental right. And so we do see some states where you see education as a fundamental right. There's a growing movement to have the right to vote ensconced in state constitutions. And so maybe that is a potential pathway forward. I wouldn't give up on the federal, but we need to evolve. What got us here, Dawn, won't get us there. At the Lawyers Committee, we have a campaign celebrating our 60th anniversary, which we've been celebrating last year and this year, and it's called The Future We Deserve. And it's based upon a couple of notions. One is that the things we look for, the things we fight for, are not just hopes and dreams and wishes. It's what Black communities, brown communities, every community actually deserves. But we know that to have that future, we have to build it, just the way the people who came before us built what we have. We are defending the infrastructure of what is essentially the Second Reconstruction, the Civil Rights Movement era legislation, the Voting Rights Act of 65, the Civil Rights Act of 64, the Fair Housing Act. But we can't only defend that. We have to build something going forward. We have to build new. So we need new paradigms. And I think those new paradigms will have to include not just the right to have something not happen to you, but also something that sounds in positive rights, something that is affirmative. And I think the right to vote being ensconced at the state and federal level is one of the most powerful positive rights we could have.
You talked a little bit about Texas and I think Georgia and just the resurgence of these laws that are generally have the effect or of restricting the right to vote.
And sometimes intent, we argue as well.
And okay, and intent. And so, my question is, you talked about litigating and the fact that a lot of these lawsuits are, long and expensive. What are the effects? What are you seeing? Unless these laws are enjoined, I mean, what are you seeing on the ground as these states start to reinstitute some of these, laws and mechanisms that generally have the effect of limiting the franchise?
Sure. Well, I'll mention two states in particular, Texas and Georgia. In Texas, and one of the early election cycles after Texas adopted its suppressive voter restrictions, one of which required what they call a signature match between your absentee or mail-in ballot and your voter registration form. They said the signatures must match. Now, that's not based upon some type of digital scan. That's based upon an eyeball test, essentially, right? And so you can imagine when you are signing a form, you may be packing your kids' lunch for the day. You may be in between shifts of two different jobs. You may be serving a client under a high pressure situation, kind of in a white collar context for lawyers among us. And so you write the way you write. And if you're a medical professional, you will definitely write in a way that is barely legible and may not actually match the way you wrote it before. And so 1/8 of those ballots were rejected because of a lack of a match. Now, we believe that that's something that's really immaterial to one's eligibility to vote, immaterial to one's right to vote, and is frankly a poor measure. I mean, one other context I forgot to mention is someone may have developed arthritis or a health condition since the last time they wrote. And so these laws are said to be, preventing cheating or voter fraud, which barely exists at all. When it does exist, it's not where people think it does. And so you see people's right to vote being absolutely denied because of that. In Georgia, that's the state, of course, where there was an effort to make it illegal to give people food and water in line while they were waiting to vote. And Georgia also had its own version of a matching requirement. It was about a date. And so when you register to vote, you provide, dates of birth, you provide all kinds of information. And it turns out on the back of the form to mail in the ballot, voters were asked to write down their date of birth. Now, instinctively, when you sign a form and write a date, you're writing the current date, the date of submission. Instinctively, so many people do that. But people who would write down the current date and not the date of birth would find that their forms would be rejected. we were able to get that provision enjoined as being immaterial to one's eligibility and the requirements to vote. We also were able to get enjoined in federal court, a preliminary injunction, I should say, not permanent, preliminary injunction with respect to the so-called line warming. So outside of that, no politicking zone of, I think it's 150 feet or so in Georgia, people can now get, food and what have you, can do line warming outside of that space. But the fact that you had to fight just to get a preliminary injunction, not even a permanent one, the fact that those laws went into effect in 2021 and those lawsuits are still not resolved, right? The fact that people have to stand in long lines in the first place in heavily minority communities, that is really a disaster for democracy. And so we are doing whatever we can to make things better, to make things easier for people to cast a ballot when they should be able to, but it is not easy whatsoever. So there's some real world implications, but the deepest implication is the one that is intangible. The Brennan Center has a report out fairly recently about voter turnout or voter participation since these laws went into effect in various states. And they're finding significant increases in racial disparities in turnout, especially in those formerly covered jurisdictions. And so we're still analyzing the ins and outs of that report, but I think there's some really compelling pieces there, because I think it signals that the biggest problem isn't just the specific individual who's turned away, it's the chilling effect on people even wanting to vote in the first place. And I think that is kind of the master design for those who I believe are anti-democracy.
So you started off in your intro, you kind of introduced AI as one of the, the greatest threats, and the World Economic Forum has ranked misinformation and disinformation as the biggest global risk for 2024. And I know you were appointed last week and would love to hear some more about that at the Department of Homeland Security, new AI Safety and Security Board. Did I get that right? You're making a face. Okay.
Yep.
I'd love to hear a little bit more about that. But in the context of, the elections, we've seen an increasing role of that misinformation and disinformation have played. And, as you said, it's always been there in some form, but it really is supercharged in this election cycle. And so how can we best protect ourselves from this type of interference as we head into the 2024 election cycle?
Well, let me first give you an example of how these things play out, and then we can talk about how we protect ourselves. So, in the 60s, 70s, 80s, 90s, and a little bit beyond, voter disinformation and misinformation was fairly primitive. You would see in predominantly Black neighborhoods posters or bills on poles, utility poles, telling people the wrong dates of an election or the wrong dates for registration cutoff, right? Different form of chicanery. But now we see something like this, something that happened in 2020. At the Lawyers Committee, we co-convened the Election Protection Coalition, which is a coalition of over 300 organizations nationwide, about 20 years old, over 20 years old, in fact, the entire coalition. And we have the 866 Our Vote hotline where voters can call in and give tips. And hopefully we can talk about that a bit later. Well, in the 2020 election cycle, during the early voting period, we received a call to the hotline complaining about strange robocalls. And the robocall, and I'll paraphrase and then directly quote, had the voice of a woman who we later learned was a Black woman who was recruited as a voice actor. And she said something to the effect of, did you know that if you vote by mail, that the information will be used by creditors to collect outstanding debts? Did you know that the information will be used by police to execute outstanding warrants? And did you know that the information will be used by the CDC to force mandatory vaccines and vaccinations? And at the end, she says, don't give your information to the man. We found out that this was an orchestrated campaign, 85,000 robocalls targeted to Black voters in multiple states. And so this is orchestrated disinformation. And here's what's so important. This is not state or government action. This is private action. These were two far-right individuals who decided they wanted to do this. And when confronted, they said, yeah, we did it, but there's nothing wrong with it. Well, of course there was. You asked what was left of the Voting Rights Act. There's one provision I did not mention. Section 11B of the Voting Rights Act prohibits voter intimidation. And the federal judge found that this rose to the level of not just general mis and disinfo, but actual voter intimidation designed to have a chilling effect on Black voters exercising their rights. Now, that was a really important case. We won on summary judgment, so it was a very big win. It's one of the very few applications of Section 11B, especially, I think, the first time we've seen it used for a robocall, something that happened through the airwaves. So that makes it something in the digital realm on its own. And Tish James, the New York Attorney General, intervened in the case and really helped us really get that one across the finish line for the victory. And these two individuals eventually settled on damages and will have to pay up to $1.2 million to our
So
clients
just
and to
so,
other.
I may have missed it, but who sued the two individuals? Like, what was the path to accountability?
We at the Lawyers Committee filed the suit
Okay.
in the federal district court in the Southern District of New York under Section 11B of the Voting Rights Act. And Attorney
Against
General
two
James,
individuals.
yes, against
Okay.
and we sued the robocall company as well, but that
Okay.
company settled quickly because they helped facilitate this intimidation.
Yeah, that was a wise decision.
Yeah.
Um, you know, so and then the other thing that you mentioned, and you talked about Tish James's intervention and so on, but what do you think the government can be doing? I mean, this is a problem that we're grappling with as a society,
Right.
of how to deal with misinformation and disinformation.
Right.
But from the Lawyers Committee perspective, what do you think the government should be doing to help us protect ourselves?
Well, a couple of things. One, just to draw the full connection to AI. If you fast forward to the New Hampshire primary, there were reports about AI created robocalls cloning President Biden's voice. And so when you put two and two together, what happened in our case, and what happened there, the FCC, the Federal Communications Commission, did take quick action. It announced the unanimous adoption of a ban on AI-assisted robocalls for elections, for electoral content. I think that's an important start. That's something governments can do. But here's the case. That is that might be the only instance of specific AI regulation that we know of. If you used a toaster to make breakfast this morning, that toaster is better regulated than AI, period. It's a strict liability concept. It's products liability. So we actually at the Lawyers Committee have rolled out a model bill that we call the Online Civil Rights Act. We rolled it out in December because there's a buzz about potential regulation on the Hill, and we want to be in that mix, and we are in that mix. And we call for simple things like a duty of care that you may see in the torts context. We call for essentially auditing, like essentially the equivalent of like environmental impact assessments before you start to excavate and dig. We want something like that to do assessments of AI tools for bias before they are released, and even ongoing assessment thereafter, and also data minimization so that all the data that's collected about us is not harvested and used without our knowledge, and we get a chance to opt out, and so it's not used against us. So all of those things, the data industry fuels mis and disinformation because it allows people of ill intent to better target us. The robocalls were very primitive, but 4 years later, they can be very sophisticated with the power of AI, targeting and cloning and what have you.
I want to go back to that concept of truth, though. I mean, that lawsuit was after the fact of they had put out this disinformation, had caused whatever harm in terms of chilling however many people from going out to vote. What, if anything, do you think the government can do to stop, mis and disinformation before it causes that harm, before it's out in, the public discourse?
Right. I will say some harm was certainly done. We did get a preliminary injunction during the early voting cycle, so we stopped it in its tracks. But obviously, 85,000 calls does have an impact.
That could be 85,000 votes.
That's right, and that can swing entire elections, right, in various jurisdictions. So one thing that could happen is, and we've talked to the federal government about this, we need an aligned federal footprint. I'm so proud of what the work that and glad to see the work that the Civil Rights Division has been doing on this in conjunction with U.S. attorneys' offices. You know, we think about the apparatus of justice, and so often people think it's oppositional to communities of color. Well, it doesn't have to be. It can work in the interest of communities of color, in the interest of democracy. And so U.S. attorneys' offices have a real role to play. And I'd love to see a great calling in, not a calling out, but a calling in of tech companies, of the companies that do robocalls on what's happening on AI. I do think that Secretary Mayorkas's AI advisory board is part of that. Now, the focus there is to protect the nation's critical infrastructure, from natural resources to the built environment to online, from attacks and what have you. But the attacks will be perpetuated by the very same AI tools that some of the tech companies are creating, right? And so I think we need a great calling in of all of these actors to do all that they can do. It has to be a public-private partnership. I don't think that governments alone can do it all. Again, Don, because it's a combination of what government action is, but also private action. And regulating private conduct is one of the most difficult things I think that laws can do.
And one question that we had that came in via the chat was, I don't know whether there was any money that came in that judgment, but could that be used as kind of, you know, for a media campaign to disabuse people of for the 85,000 people that did receive that call? If there was redress or a money judgment, could that be used to send something out to those people to let them know that that information was incorrect?
There have been notifications to those individuals. The dollar amount will be up to 1.2 million. First, there's money that will go to those who register as having been impacted. There's a fund that's being held by the New York Attorney General's office, a trust fund, so to speak, their client fund. And also the lead name plaintiff was the National Coalition on Black Civic Participation, our good friend Melanie Campbell, who leads that amazing organization. And so they got an initial payout. And the first conversation we had was about how to best leverage those fees, those funds, to do good, to correct these wrongs. So it's not just about the 85,000, it's more about the 85 million, right? Who are frustrated, concerned, confused. Because if you think about it, Dawn, there's some people who haven't voted since the 2020 election, or maybe even since the 2016 election. And think about how many times laws have changed in their jurisdiction during that time. You had the pandemic era expansions, even in deeply conservative places, of new ways to vote. You had drive-through voting in Harris County, Texas. And then you saw some of those lapsed temporarily, and some of those were beaten back by voter restriction, but voter suppression laws. And then there's been litigation about those. So the rules may have changed multiple times. And of course, people get purged from the rolls too, simply because they didn't exercise their rights in what the state deemed a timely fashion. So I'm oversimplifying there, but this is a voter purging, or what they call list maintenance, is just a very common and sadly accepted practice. So voters need information from trusted messengers as much as possible. And I think that's where the Election Protection Coalition comes in. It's not just us in DC and national organizations. We work with community partners all over the country, and they are the most trusted messengers. I should mention too, the 866 I Vote hotline that we operate is not just the one in English. There's also sister hotlines in Arabic, a sister hotline in Spanish, and also a sister hotline in multiple Asian languages as well. And so we work together to serve as many communities as we can, those communities that sadly have been historically and even today more likely to be disenfranchised.
So the hotline was where I was headed next, and that was in line with the very first question that we got in the chat, which was thanking you for your work, to all the work you do to support our democracy, but specifically asking, what do you need for November 2024? Do you need in-person volunteers to help voters, or lawyers volunteering remotely to support regions outside of New York? When will you have your training sessions for volunteer lawyers for Election Day early voting? But I think couched in that question is just, if you want to talk a little bit more about how that hotline works nationally and how it works in New York, and specifically how New York lawyers work with the hotline and how they could potentially get involved.
Sure. Well, this coalition came together as a combination of efforts of a number of civil rights organizations after the 2000 election debacle. And we don't have to revisit all of that, but the clear implication was that democracy was at stake, democracy was on the line, and of course, democracy is on the ballot. And so we were very concerned, again, at that time about election administration, and we realized that voters were very confused. The things that we were seeing on television, the things that we heard about happening in the courts didn't really make intuitive sense to a lot of people, and that voters needed information from a nonpartisan and trusted source. Because before election protection, you had, groups like Legal Women Voters, which does really good work about advising people on, here are the records of candidates and what have you. But there was no nationwide concerted effort to provide people nonpartisan, unbiased, truthful, and trusted information. And so that's what we came together to do. The hotline is powered by a couple of important centers of gravity. One center of gravity is our community partners, lay people who are not lawyers at all, who run the field program all throughout the country.
Who are some of those community partners in New York?
New York. I'm trying to think about who's in New York. New York is very robust. There's actually some national groups that have local presence, like Latino Justice Pro Def, Asian American Legal Defense Fund. There's actually a New York Voting Rights Consortium, which has been in existence for some time. They do everything from redistricting to electoral pieces. And what I love about consortiums like that in New York is that they don't just advocate and throw bricks, so to speak. They engage directly with election commissioners, with the Secretary of State's office. They engage directly with the power brokers and the decision makers well before the election and during the early voting cycle and on election day. So it's really, they're essentially tables like that in multiple states. So it's not just national organizations parachuting in. It's national organizations not as an umbrella, but as an underbrella to support what the local and regional actors are doing. We have great partners in so many states: Georgia, Michigan, North Carolina, Louisiana. And so front and center, you will see the local actors, the local coalition, as the trusted messengers and the people who live in a jurisdiction. So that's one center of gravity, the field program, which is the people who are most likely to have folks boots on the ground during early voting and election day when people are voting in person at both periods. And then there's the other center of gravity, which is the lawyers. And that's where the bar comes in. We recruit, train, and deploy volunteer lawyers because when a voter calls the hotline, the call is answered by a lawyer who's been trained by us based on our protocols and FAQs. And so we train people to answer calls for any state, not just one state, but for any state, and we give them that information. And so it's a lot, and it's about a couple hours worth of training, but lawyers can sign up for shifts that are usually about 4 hours. We encourage people to sign up for as many shifts as possible. In the 2020 cycle, we hit epic numbers, again, because of the political stakes and because of the pandemic impacts and what have you. We recruited 14,000 individual attorneys.
That's amazing.
Nationwide for the hotline. They filled something like 65,000 various shifts on the hotline. And we had over 250,000 voters that called into the hotline. That's not to mention the touches and impressions on social media, text, what have you. And so I don't think the numbers are the thing to be impressed by. It's just to give you a sense of the scale and the volume. In fact, sometimes I wish the numbers were less, because that means that's 250,000 voters who are confused, who are concerned, who had a problem. But when they call, we want to be there for them. And that's exactly how this hotline works. With those two centers of gravity, I should note that we lead the legal piece with the lawyers, but our partners at State Voices and Common Cause lead the field program. And they've been really good partners in that work.
And then what happens when the lawyer gets the call, right? So you have 250,000 people that call into the hotline. You've trained these folks. They're by the phone. They get a legitimate issue. I don't know if that's in New York or, in another state. What happens then?
Well, first thing, we have a custom built database. We call it Our Vote Live. And so The person taking a call, the attorney taking a call, will log a matter into the database and create a ticket, just like you would for an IT issue or something that needs to be addressed and fixed. And we have multiple kind of virtual and in-person command centers where in this centralized database, which our partners have access to, based upon what state and jurisdiction is from, we can troubleshoot. And we do that troubleshooting together. We determine what needs to be escalated, what requires to deploy boots on the ground, what requires legal action, which is not always the case, but you're familiar, Don, I know, with election day suits, which are quite often to keep polls open because the polls precinct open late, or they run out of paper ballots, or to require people to be able to vote if they're being turned away improperly, what have you. So it's really about a model of like massive nationwide decentralized communication and troubleshooting and workshopping every voter, every problem. And I have to tell you, having done some of the work early in my career on the ground, there's nothing more powerful and more fulfilling than being able to help someone who was about to be turned away from being able to vote to actually cast a ballot, provisional or otherwise. It is just such a powerful feeling. I remember the first time I was able to do that, and I'll never forget it.
Well, I wholeheartedly agree. I firmly planted myself in a polling place in Philadelphia in 2020. And, you know, I think voters from whatever stripe feel confidence in knowing that there is some sort of boots on the ground, and particularly if there's a lawyer there to make sure that they can successfully exercise their franchise to vote. So thank you. You know, there is nothing more important, you know, in terms of elections and election day, in terms of providing that service so that people know that they can walk in unencumbered and successfully vote.
Thank you. Appreciate it.
And are there, again, turning just because this is the year, I mean, are there other resources that you recommend well, before I get to that question, I wanted to ask the question because I think one of the things that people have in mind is just how do they get involved? So members from the city bar, I don't know if you're taking, you said you had 14,000 volunteers, which is amazing, you know, lawyers, but I know that we have lots of enthusiastic folks that want to help and get involved in the city bar as well. And so I would not be doing my job if I did not ask that question about whether you are taking additional volunteers, and if so, and if not, how can New York lawyers, members of the city bar, help and get involved?
Well, we are taking lawyers. Slots are filling up already by arrangement, in part because we do rely quite often on law firms to host call centers. They work so closely with us, firms all throughout New York City and nationwide, but New York City has a number of them. So there's two ways. First, any individual lawyer can go to our website, 866ourvote.org, 866ourvote.org. That's the website for the Election Protection Coalition. Of course, Lawyers Committee is lawyerscommittee.org. And so on the website, you can see the two tracks, how to volunteer if you are a volunteer lawyer or someone who's not a lawyer, right? And so in this case, it would be for lawyers. And you can sign up in that way. I also would suggest people who work at, especially mid to larger size firms, talk to your pro bono coordinators, because we are in connection with about 200 pro bono coordinators from firms all throughout the country. So that's going to be your AmLaw 100 and way beyond, of course, because we often have arrangements with them about how people can sign up from their firm, because the slots certainly do fill up. I'm not going to say everyone is scheduled, obviously, for the general election. There's still primaries happening throughout the spring and early summer, and those are important slots as well. I would encourage people to sign up, and if you've never done it before, start doing it now. Start doing it during the primary season. That way you get acclimated to it before you get to the general election.
And let me just ask a follow-up, because we got a more specific question in the chat about this, about, you know, you talked about the schedule and signing up for slots, but, you know, what are generally the hours? And, you know, what are lawyers I don't know. I think when I did it, I haven't done it every election cycle, but I think when I did it, there was kind of a central room that people took calls. And so I don't know now in the age of post-COVID, people are doing it from their own offices when they take a slot, and are they waiting for a call to get in? Specifically, the question that was posed was, do lawyers tend to be very busy when they handle the hotline? So I don't know if you can give a little bit more color about just what it looks like, in terms of signing up for a slot.
Great question. So the way it used to be that we had these massive call centers at firms and at our office, and everyone had kind of kiosks, almost like a telemarketing center. Obviously, we had to scramble. We were literally in the midst of a primary in March of 2020 when the pandemic started to hit on the East Coast and Mid-Atlantic. And so we had to scramble and set up an entirely different apparatus to allow everyone to be remote. And so that, just like you see hybrid offices these days, we still have folks remote. Some firms like to have people coalesce who are volunteering at their firm in one conference room, but you can do it remotely from the comfort of your office, from the comfort of whatever your remote work situation is. We just have to do a lot of tech checks. And we also have now new security overlays, given that people are using so many different ISPs and different machines, right? So it costs a lot more and it's a bit more involved, but you can do it from anywhere. The shifts are typically 4 hours, so the shifts are not long. So if you imagine like your billable day, you can get a lot done and bill a lot, and hopefully your firm allows you to, or your company allows you to bill your pro bono hours is 4 hours. We do encourage, Dawn, attorneys to sign up for more shifts. Like, honestly, I don't want 14,000 attorneys again. I'd much rather have 8,000 doing more shifts, because the more you do it, the more fluid you'll be. And honestly, the better it is for us, because we have to have a whole seasonal apparatus of staff, almost 20 extra staff, just to do the troubleshooting when people have questions. Not
Just
voters, but the
answer
volunteers.
questions.
But the volunteers, yeah.
Right.
People ask the questions, have questions, right? So we encourage more slots, but it's 4-hour slots. So you can fit it within your billable day. If you think about an early voting week in a particular state, right? You can sign up for 1 or 2 shifts multiple days and still bill some hours. You don't have to be fully out of pocket. And unlike pro bono litigation, you don't have to get, route through lots of approval chains, right? Every firm is a bit different, but you don't have to route through approval chains, and it's not something that is going to go on and on for weeks. It's time limited.
Yeah, and it's also a great way of having real impact without traveling to a state. And every state has its election administration challenges and has need of election administration and election protection support, but a lot of the focus does go to certain swing states. And the fact is that the hotline provides a critical role for people that can't or won't travel. You can still be of immense help.
It does. Let me say this too. I think that some people gravitate to swing states, and I completely get that. Even a nonpartisan work on that. I don't think I've ever done election coverage on the ground in a swing state. I think I've only done
Where have you gone?
Well, early in my career, Louisiana, where I'm from, Alabama, Mississippi. Those are some of the places I frequented the most when I did work on the ground. And so, people would think, oh, the election is not in doubt, right? The results. That's not always true as far as the presidential, right? But it's really, you think about the so-called down ballot races that impact people's daily lives. And then even regardless of the state, you'll have like an Austin in Texas or New Orleans in Louisiana. These places that are viewed as oases of maybe more progressive thought, or what have you, or different politics, you still have problems there. Let me tell you, in New Orleans, all the people who ran the election, the registrar of voters, the clerk of court, the poll watchers, these are all Black folks. There's still problems.
Mm-hmm.
There's still problems, right? And we still have to be there. So it's not about an us versus them. It's about helping the machinery of democracy along, and also buttressing against the actual intentional threats as well.
Yeah. Thank you for that, because that's really important framing. It's not about one particular election. it's about helping powering democracy and making sure it works.
Right.
My last question was just whether there were any other resources. We definitely talked about the hotline, but that you would recommend either voters generally or members of the city bar use to remain informed and engaged as we head into the 2024 election cycle.
Yeah. The Department of Justice announced some resources in January, really more of its kind of its game plan for what it's doing. I encourage folks to take a look, and I'll get the URL if I can, or we can send it out afterwards. And I think it really sets a good tone. They talk about how they're coordinating with U.S. attorneys' offices. I think that is really important to note. There's always your League of Women Voters locally that has their election guides that are nonpartisan, but do a little bit more than we do. We focus on voter protection. They focus more on other forms of voter information. So I think those are also very, very important for people to take a look at. I would also say it's not maybe like one specific source of resource, but just really understanding the pulse, whether it be in the news cycle or otherwise, or local forums. What are the issues that the state and local advocates are concerned about? They often have, open forums, and sometimes these are online. I think really getting a sense of what are the issues people are concerned about in terms of access before an election means when you volunteer for the hotline, you may not be a surprise. You may be a little bit more prepared for the issues that are coming up. So I would highly recommend that as well.
Do you have any suggestions? I mean, I think some people are more plugged in than others, but I think that's another very astute and helpful suggestion to kind of clue in to what the advocates are advocating. Right. Do you have any suggestions for how people could do that?
One, a66rvote.org. I think we either have or will be beefing up the content in terms of information. So we don't do GOTV, get out the vote, in terms of voter mobilization, but we are trying to do more of GOTM, get out the message, so to speak. And so I think through that GOTM exercise, A66 Vote will start to have more information in that regard in specific states, and also ways to connect to the captains of state tables. So, for example, in Georgia, I can't recall who's leading the state table in New York this year, but in Georgia, I know it's Laureata Law Firm and a grassroots advocate. They're co-leading that state table, so there's people who are approachable and accessible for folks, regardless of where you come from.
That's great. Well, we are almost at time, and so I just want to close by providing you an opportunity. I've been directing most of the questions to the extent that there's anything else you'd like to say to the city bar members and beyond that have joined us today for this law day. But just generally want to really thank you again for taking the time to speak with us.
Thank you, Dawn, and thank you to the city bar. Having lived in New York for about 13 years, I know it's such a vibrant city and a very vibrant state. I was actually supposed to fly to New York on September 11, 2001, which was a day of tragedy and horror for so many people. I was coming to move to the city to start my career. I ended up being delayed by about a month. And so I came to the city at a very somber time. I'll never forget, though, that September 11th was also an election day. And so I say that not for partisan reasons about how the election could have turned out differently on that day, but because I know that there are people who were going about their daily business and also trying to figure out how do I vote in the middle of my work day. And of course, the tragedy scuttled all of that. And so I think it's important for us to remember that voting in this country is harder than it should be. And so part of our goal is to make it easier for people. That's what it should be. That's the moral clarity that I have about it. And also, we shouldn't take for granted the rights that we have. There's a precarity to access to the ballot that shouldn't be real, but it very much is. And even in strongholds that people think, oh, my party controls the stronghold, so it's good for me or my party, don't ever assume that. Don't ever assume that. We should not have a false equivalence between the politics of a party and the politics and the needs of a people. I've said that to the RNC and the DNC alike. And so we had to swallow these different types of actors over time because, this is all due respect to party folks, but they put the interest of the party first, even if those interests they think are aligned with communities. We always put the interest of communities first. And so we have to make sure that we don't have a capture by any partisan apparatus because we start to lose sight of the thing that matters the most, the voice of the people. And then finally, I'd say, our modern mission at the Lawyers Committee is to ensure that the communities we serve the most, Black communities and other communities of color, have the voice, the opportunity, and the power to make the promise of democracy real. For us, democracy is not just about an election. It's about representation. It's about access. It's about voice. It's about the ability to exercise self-determination, the freedom to learn truthful curriculum in their classrooms. We're litigating those issues now, just like we're litigated affirmative action. The access to fair and safe and affordable housing. That's what the project of democracy is supposed to be about. Elections are a key part of it. They're the crown jewel of it, but there's a much broader spectrum. So when you're engaged in defending the right to vote, you're also defending rights for people to be full stakeholders in what this country is and what it claims to be. And so I thank you for everything that you all do through the City Bar every day to make that happen.
Well, thank you, and happy Law Day.